appellant in the appeal, Cadder, and Her Majesty's advocate.
The practice in Scotland of detaining persons for up to 6 hours so that the police can question them in relation to allegations of criminal conduct is regulated by statute. The procedure dates back to 1975, when the Thompson Committee on Criminal Procedure in Scotland said that the public interest in the detection and suppression of crime outweighed any disadvantage to the detainee in being subjected to police questioning in the absence of his solicitor. It did not rule out the possibility of his being given legal advice before he was questioned, but this was to be at the discretion of the police. The rights of the detainee were to take second place to the public interest in allowing the police to question him without being deflected from their task by the presence of a solicitor. The statutory procedure was framed on this basis. There was to be a right to have intimation of his detention sent to a solicitor, but there was to be no right of access to legal advice before he was interviewed. The appellant in this case was subjected to this procedure. He was detained by the police on suspicion of having committed a serious assault. He was told that he did not have to answer any questions beyond giving his name, address, date of birth, and nationality, and that he was entitled to have a solicitor informed of his detention. He was then interviewed without a lawyer being present. He made a number of admissions to the police during this interview. The Crown relied on these admissions at his trial, and he was convicted. The question is whether the procedure to which the appellant was subjected was a breach of his right to a fair trial. This is a right which is given to everyone by Article 6 of the European Convention on Human Rights. In determining this issue, the courts are required to have regard to decisions of the European Court of Human Rights in Strasbourg. In a case called Saldus against Turkey, which was decided in 2008, the Grand Chamber of that court held that there had been a violation of Article 6 because Saldus had not had the benefit of legal advice when he was questioned while in police custody. The appellant sought to appeal against his conviction on the ground that that decision applied to his case. He was refused permission to appeal by the High Court of Justiciary. It relied on its previous decision in McLean against Her Majesty's advocate, in which a court of 7 judges decided not to follow Saldus because the guarantees otherwise available in the Scottish legal system were sufficient to provide for a fair trial. The Supreme Court gave the appellant permission to appeal, and it has carefully examined the question raised by the decision in Saldus. It has concluded that the decision in McLean cannot be held to be good law in the light of the European Court's ruling in Saldus and subsequent cases, and that it must be overruled. The European Convention requires a person who has been detained by the police for questioning to have access to a lawyer before being interviewed, unless, in the particular circumstances of the case, there are compelling reasons to restrict that right. The balance which the Thompson Committee struck between the public interest and the rights of the accused cannot be reconciled with the Convention right to a fair trial and the need for protection against the risk of self-incrimination. If Scotland were not to follow the example of others in reforming its procedures in the light of Saldus, it would be almost alone among all the member states in not doing so. As there were no compelling reasons for restricting the right in this case, the appeal must be allowed and the case remitted to the High Court. The Supreme Court is well aware that this decision will affect very many cases in Scotland which have not yet gone to trial, where a trial is still in progress or convictions are currently still under appeal. But there is no room for a decision that favours the status quo simply on grounds of expediency. The issue as to whether the current procedure violates the right to a fair trial is one of law, and it must be dealt with accordingly by the courts and by the Scottish ministers. But the Supreme Court does feel it appropriate to rule today that its decision does not permit the reopening of closed cases, subject only to the possibility of a reference by the Scottish Criminal Cases Commission, which was not a party to these proceedings, cases which have been finally determined because the conviction was not appealed or because the appeal has been finally disposed of will not be affected by it. The court will now adjourn.